Happening right now, there is a march calling for women's rights. This is outside the Planned Parenthood in Plano. The crowd's been growing in the last hour. Once this group is fully gathered, we're told they do plan to march to the Plano courthouse, and it's about a mile away from where they are gathering right here. All of this, of course, coming on the heels of the draft opinion you've heard so much about, the vote as well, leaked out of Politico from the Supreme Court, indicating that the court is poised to overturn Roe versus Wade in a trial that actually originated in Dallas. Chief Justice John Roberts confirming earlier today that the leaked opinion is, yes, very real. But he also stressed this does not mean it is the court's final opinion. On the subject of the leak itself, he says it is a betrayal of the confidences of the court and a singular and egregious breach of trust. He has also asked the marshal of the court to launch an immediate investigation into the source of the leak. Our team coverage as we get underway at 5 here with Jack Fink. Jack, I know you spoke with a constitutional law professor over at SMU, and for context, since this is the first time and a first ever leak from the Supreme Court, educate us on exactly what a draft opinion exactly is and what it means.
Well, Doug, if the majority in the draft opinion holds, Professor Dale Carpenter says by summer, if not earlier, the Supreme Court will overrule Roe versus Wade from 1973 and Planned Parenthood versus Casey from 1992, meaning there would no longer be a fundamental constitutional right to abortion in all 50 states. But as the Chief Justice said today, this is not a final draft that has been made public. And so Professor Carpenter says there could have been changes in the justice's views.
So we're talking about 3 months having passed. There may well be additional drafts that have been circulated based on reactions that people in the majority had, or there may be a dissent that's now circulating.
Professor Carpenter says he would not be surprised if the court overturns these decisions based off what he heard from the justices during their oral arguments in December when they considered Mississippi's law, which bans most abortions after 15 weeks. The draft ruling obtained by Politico was written by Justice Samuel Alito, who said Roe was egregiously wrong from the start. The Constitution makes no reference to abortion, and no such right is implicitly protected by any constitutional provision. Carpenter says he believes the key finding by the majority in the draft was that the prior abortion rulings were, quote, egregiously wrong.
Our system says that cases like that have to be left to the legislatures and not to the courts. So that was a significant finding by the Supreme Court.
And many Democrats in Congress say they need to pass a federal law that would essentially codify Roe versus Wade and Planned Parenthood versus Casey and provide a right to an abortion in all 50 states. The Democrats could pass that in the House, but because the Senate needs 60 votes to begin a debate, and because it's 50-50, it likely wouldn't pass there. Doug?
So let's play it out for a second. Let's just say, for instance, Congress does pass a federal law on this. Could that be challenged as well?
Well, Professor Carpenter says yes, there could be lawsuits filed challenging any law passed by Congress, either way, including if Republicans were to win a majority after the midterms this November. And that could very well end up back at the U.S. Supreme Court. And the same is true for any state laws that may end up being passed. They, too, may end up at the Supreme Court if challenged. Doug?
So far to go, but we're learning along the way. Jack Fink, thank you very much.